Hello everyone, my name is Geetanjali Sharma. I'm a graduate of Cambridge University, having specialized in the areas of international trade law and other aspects of international law. In this module, I present before you the second chapter on dispute settlement understanding titled The Enforcement of WTO Rulings. As you'd know, this particular module is in continuation to the introductory module on dispute settlement understanding that has already been provided to you. In that module, we traced the overall historical transition from the erstwhile GATT regime to the modern day WTO dispute settlement mechanism, or the dispute settlement understanding as it is popularly known as. We looked into the various benefits that the modern WTO DSU regime provides to different actors in the WTO framework. In this particular module, we delve deeper into this institution of dispute settlement understanding, or the dispute settlement body, and we critically analyze the different remedies and the overarching scheme as provided under various provisions of the dispute settlement understanding. As I take you through the learning objectives as have been highlighted for this module, we will understand the nature, scope, and the interesting aspects in which these concepts play out in the framework of the modern day dispute settlement understanding. So moving on, the first learning objective of this particular module is to understand various aims of the remedies that have been designed under the WTO dispute settlement understanding. Broadly, there are three main remedies that have been designed under the framework of modern day dispute settlement understanding. Our idea would be to investigate into the nature and scheme of each of these remedies and to understand the basic legal nuances behind the remedies. The second is to particularly understand the nature and scope of the concept of cross-retaliation. Here, I'd like to mention that WTO dispute settlement regime, by continuing or rather introducing this new concept of cross-retaliation, makes WTO a very unique body within the larger ambit and body of international law. International law largely has outlawed the concept of countermeasures. However, as an organ of international law, WTO still continues, or rather promotes, the concept of cross-retaliation, which in a way is nothing but a form of countermeasures. And this special remedy has been designed to taking into account the various nuances behind the politics and economics of international trade law regime, and we'll understand how this particular concept plays out in the larger scheme of WTO and international law. Now, the third objective before us today is to understand the role of an arbitrator in granting cross-retaliation. As I've just mentioned, cross-retaliation is slight of a controversial provision because of it being very unique and new to the modern day international law regime, where otherwise outlawed, it only finds a presence in the WTO range of things. Therefore, to what extent is this remedy of cross-retaliation actually to be applied, and what is the role of the arbitrator, who is the chief designer of how a cross-retaliation has to be implemented by member states, becomes very crucial. The various concepts that go about in defining and implementing cross-retaliation would become crucial for our analysis in this present module. And lastly, we'll provide a critical overview of the various regimes of remedies that have been designed under the WTO scheme, and whether from the aspect of both the developing and the developed world, to what extent can we say that they are effective. Now moving on, as I mentioned, we will now take up every remedy and various schemes as have been provided under the dispute settlement scheme. So first, I would draw your attention to Article 3.7 of the DSU, and to understand the provision in detail, I'd read out the specific phrases in this particular article and how they provide an overall scheme of how the dispute settlement remedies have been designed. So Article 3.7 of the DSU states, and I read, in the absence of a mutually agreed solution, the first objective of the dispute settlement mechanism is usually to secure the withdrawal of the measures. So the first solution that is being provided is securing the withdrawal of the measure concerned, if these are found to be inconsistent with the provisions of any of the covered agreements. Now, this point being very clear that the first objective is to secure the withdrawal of the inconsistent measure. The provision goes on to read, the provision of compensation should be resorted to only if the immediate withdrawal of the measure is impracticable and as a temporary measure pending the withdrawal of the measure which is inconsistent with a covered agreement. Therefore, the scheme of compensation is also introduced into the design of remedies. However, it is specified that it will be resorted to only if the immediate withdrawal is difficult or is impractical. And the second rider provided is that the compensation measure has to be a temporary measure and not the ultimate objective of how the remedies have been designed or why the remedies have been designed. Therefore, this is the second option given to member states, but it has to be implemented only when the two riders, as have been pointed out, will get fulfilled. Now, the last aspect, which is the most interesting aspect for our analysis for the future course of this module, is the provision of cross-retaliation, which reads as follows. The last resort which this understanding provides to the members invoking the dispute settlement procedure is the possibility of suspending the application of concession or other obligations under the covered agreement on a discriminatory basis vis-a-vis the other member states, subject to the authorization by the DSP of such measures. Now, the third resort is here the concept of retaliation is being introduced. And as I was mentioning, cross-retaliation would be considered as a subset of the overall concept of retaliation, and that is the last resort which member states have been afforded to, and the specific applications of it have been defined further when we talk about the role of an arbitrator and how the scheme has to be executed. Therefore, from the overall scheme of Article 3.7, we have first the withdrawal of the measure, second the compensatory scheme, and last resort, which is the concept of retaliation. Therefore, to just reiterate, where can one find these specific provisions? Now, Article 19.1 of the Dispute Settlement Understanding talks about the withdrawal of the inconsistent measure. Then we have Article 22.1 that talks about the concept of compensation. The last being Article 22, which talks about suspending the application of concessions or other concessions, which in common parlance is known as retaliation. Now, this is just a brief transitory scheme of how the remedies were designed under the erstwhile GATT regime of 1947, and how Article 3.7 that we just stated is in a way the newer concept or something which takes you far ahead of what was otherwise envisaged under the erstwhile GATT regime. So under the erstwhile GATT regime, you had Article 23.2 that provided that a complaining nation could be authorized to suspend concessions or obligations under the GATT, provided two substantive conditions were fulfilled. First, the circumstances are serious enough, and the second, that the proposed suspension is appropriate. Now, as you'd see, the result of interpreting this particular provision rather gets slightly murky because of the thresholds being provided under Article 23.2 being very vague. Now, these are vague standards, and over and above this, as you'd remember from your previous learnings, that under the GATT era, there was a prevalence of the positive consensus rule, and that rule ensured that the losing party could effectively veto any proposal for suspending concessions. Therefore, any member state that wishes to take recourse of suspending concessions, first of all, has to fulfill a very vague criteria and prove that the circumstances are serious enough, and second, that the proposed suspension is appropriate. And that too, even if such a criteria is fulfilled and the member state is able to prove that the requirement of such suspensions of concession is important, the losing party could effectively use its veto and, under the regime of positive consensus, negate the very proposal, and therefore it rendered the whole regime effectiveless and meaningless. Now, there have been illustrations of how provisions of 23.2 were misused. We have the EEC Oilseeds second case, where the suspension of the concessions was blocked by the European Commission, and then you had and by the way, European Commission went on to state that it will move out of the WTO or the erstwhile GATT framework if such proposals were implemented. So that was the level of threat that members could give and the extent to which they could veto any such implementation of suspension of concessions. Then you also had the US Superfund case, which was blocked by the United States, again a very big player in the World Trade Organization today and the erstwhile GATT era as well. Now, all of this resulted in academic scholars such as John Jackson stating that the GATT system suffered from certain birth defects, now linked very much to its inadequacy of enforcing and implementing the various remedies that were designed in that era. Therefore, WTO, when it was designing its scheme of remedies in 1994, it was a very challenging task ahead, and they wanted certain bold actions to be implemented in order to make the overall system of WTO functional and important. And therefore, pursuant to Article 22 of the Dispute Settlement Understanding, the first thing that was implemented is to have the concept of negative consensus rule, by virtue of which any country, especially the losing country, cannot prevent the process of retaliation by blocking such a proposal. Therefore, the negative consensus rule meant that everyone had to veto such a proposal, including the member state which wanted to implement such suspension of concession for it to be valid. And this, in theory, becomes impossible, or rather, such a thing would never happen, and therefore, in effect, all such retaliation measures, if approved by the DSP or the dispute settlement body, would become effective on its own. Now, the dispute settlement rules are further elaborated, and we now talk about specifically the concept of retaliation. Now, as I'd said, that retaliation is a unique concept because to a great extent, and especially when we talk about cross-retaliation, is something where parties, the member states of the WTO, have carved out, or they have come out of the usual rule of countermeasures, which is otherwise outlawed under international law. So, delving more into the nature and concept of retaliation, I present before you the various types of retaliation that have been envisaged under the scheme of the WTO Dispute Settlement Understanding. So, first we have the concept of parallel retaliation, where the complaining party should first seek to suspend the concessions within the same sector where the violation is found. So, if a violation has occurred in the GATT sector, or the goods agreement, the retaliation by the other member state also must be in the goods agreement itself. Second is the concept of cross-sector retaliation. If the party considers that it is not practical or effective to suspend concessions within the same sector, it may continue to seek suspension in other sectors under the same agreement. Now, just to clarify the difference between parallel and cross-sector retaliation, to further give you an example, if there has been a violation, say in the transport sector, in the delivery of cars, and that is the particular transport sector, then parallel retaliation demands that the complaining party should retaliate in the same sector as well. Whereas cross-sector retaliation says that you stay beyond the ambit of the same agreement, which is, say, the goods agreement or the services agreement, and you retaliate into a different sector. For instance, from transportation, you could move to, say, food, or if you talk about GATT specifically, from a recreational sector, you could move to another sector, say, tourism. So that is the concept of cross-sector retaliation, but you stay within the confines of the same agreement. Now, the third form of retaliation is the cross-agreement retaliation, where if it is found impractical or ineffective to implement a cross-sector retaliation when the circumstances are serious enough. So that again is the second rider, first being impractical and ineffective, a condition which was also present under cross-sector retaliation. Now, a cross-agreement retaliation, in addition, also warrants the circumstances to be serious enough, and that party may further seek to suspend concessions under another WTO agreement. Both cross-sector and cross-agreement retaliations are collectively referred to as the concept of cross-retaliation, and they have been enshrined under various provisions of DSU, that is Article 6, 16.4, 17.14 and 22.7. Therefore, a classic example of cross-agreement retaliation, as we'll give a live example of United States and Antigua, Barbados, the online gambling dispute, the US online gambling dispute, is when a violation has happened, say for instance in the goods or the services sector, but the retaliation actually happens in the IPR sector, which is covered in the TRIPS agreement. So there you make a transition from one agreement to the other agreement, and that is cross-agreement retaliation. And as stated, the conditions for a cross-agreement retaliation would be both being impractical and ineffective, and at the same time the circumstances being serious enough. Now, we talk about the legal aspects of what do we specifically mean by these terminologies that have been presented before us. So you have the meaning of the term effective. Now, the impact of a suspension must be strong and have the desired results of inducing compliance. So as lawyers, or as judges, when the term effective is being implemented from the perspective of a member state, you need to take into account that it has to be strong and must lead to the desired result of inducing compliance. Because if we go back to our original slide of Article 3.7 and the main aim of the dispute settlement understanding, the aim is to withdraw the inconsistent measure, and therefore the idea is to maintain the status quo, that such inconsistency gets removed or eliminated, and therefore the idea behind retaliation is also to achieve the same, which is induce compliance and remove all the ill effects of the inconsistencies. However, it's easier said than done, because while executing what may be effective, member states may not have all the free hand in getting the desired results by virtue of executing the remedies because of several factors. Now, a very simple factor could be the imbalance in trade volume. For instance, if country A is a small country and has only 2 or 3% impact on the trade of country B, even if it is trying to retaliate against country B and it uses its margin of that 2 or 3% of entire trade ambit and retaliates to that extent, still for country B it will remain that amount of retaliation will not have any impact on country B, merely because the sheer volume of international trade that happens between the two countries is very, very less or insignificant. And that is also linked to the second aspect, where there is an asymmetry in the market power between both countries, where we have the developed world and the developing world, where the flow of goods, services, IPR, or any nature and aspect of trade may be very less, and therefore even for country A, whatever be effective for it may not have the same desired impact on country B because of the sheer less volume of trade between the countries. Therefore, this aspect becomes a roadblock in ensuring that remedy schemes are uniformly applied in the modern day scheme of dispute settlement understanding. Now, moving on to the legal aspects of cross retaliation, as I stated, that cross retaliation, especially under cross agreement, has to prove through 3 thresholds. It has to be practical, it has to be only when a scheme is impractical or ineffective that you move on to do cross retaliation across agreements, and the situation has to be something that warrants a serious circumstance. So here we must take up a case study which is one of the most illustrious and famous cases of both the services agreement and a classic case of dispute settlement understanding that has implications not just from a legal economic point of view but also from a political point of view. The case reinforces the belief of the modern day WTO system, where even smaller countries that have low or insignificant amount of trade contribution to the global trade have been armed and equipped with the tool of cross retaliation, where they can influence larger powers and powers as big as the United States in order to effectively get their remedies executed or seek compliance when they have been wronged and when they want to initiate cases against big trade giants. So this dispute, I won't go too much into the facts because the facts have been covered in the services module, but I will specifically talk about the dispute settlement remedies aspect of it and how cross retaliation here was discussed by the dispute settlement body. So this dispute related to this particular service entry under the GATT agreement, which is recreational, cultural and sporting services. Now, in this case, Antigua and Barbuda were the ones who had won a case successfully against the US, and it was their turn now to seek compliance with the United States. Since it did not comply, they wanted to take up retaliation. Now, there were different modes available before them to seek retaliation. Now, they realized that the retaliation in the same sector or even in the same agreement, which is the GATT agreement in this case, will not be practical or effective for the reasons that have been mentioned as below. Now, the reasons were that now Antigua and Barbuda, as you know from a geographical point of view, they are two small island nations. And in terms of size, geography, and the contribution to international trade, it is minuscule when you compare it with a giant such as the United States. So you had Antigua and Barbuda who had made commitments only in the entertainment services. They realized that if they retaliate in that narrow segment of entertainment services, where their volume of trade is anyway low, they would be the ones who will be suffering by virtue of this retaliation, because they will be the ones who will be deprived of the Hollywood movies, which is a great source of entertainment in their countries, and also for their own consumers to move to a different segment when they've been deprived of all the services that they received from the United States would be a high switching cost. So the volume of trade of these countries been insignificant, and the heavy reliance of the consumers on the services being exported from the United States and the high switching cost that the consumers would have to bear, it was realized that the suspension within the same sector or the same agreement would make the products expensive for its consumers, and therefore it was an impracticable solution for the country, and therefore it decided to retaliate and move to a different agreement itself, which was the intellectual property rights. And United States, as is known, that is very protective of its IPR, being protected not just in the US but across its border in every aspect, in every corner of the world, was definitely was hit to a very great extent, because that will lead to a lot of piracy of its movies and other literary works, which would thereafter have ripple effects for other countries in the world also. And therefore this political and economic decision of Antigua and Barbuda to retaliate in a different agreement provided to be very, very useful for them, and at the same time induced compliance from the part of United States. Now, there were other cases in which cross retaliation happened. So you have the famous EC Bananas, the third decision, where Ecuador was the requesting member and it sought cross retaliation again in the TRIPS sector, whereas the violation had occurred in the GATT, the goods agreement, and the GATTs, which is particularly the distribution services agreement. You also have the US Upland cotton case, another very intense decision where a great amount of legal analysis has gone into the nature of cross retaliation and how that has to be calculated. So you had Brazil, which sought for retaliation and retaliated in the GATT in the TRIPS sector, whereas the violation occurred in the goods sector, which is GATT 1994 goods agreement. So now we move on to the third learning objective that we enumerated in the beginning of the chapter, which was the role of an arbitrator in granting cross retaliation. So what goes into the mind of an arbitrator and how is the quantum of cross retaliation determined is something which is the role of a special arbitrator that is set up under the scheme of dispute settlement body. So we have the law as the arbitrary decision in this regard being final and binding and not subject to judicial review. The role of the arbitrator is to assess the legal requirements for the authorization of retaliation, which includes the level of equivalence to the damages suffered. So the test as demarcated and as defined under the dispute settlement understanding is popularly known as the trade effects test, where the level of equivalence has to be taken into account when any form of retaliation is authorized, and it has to be in proportion to the damages that have been suffered by the member state. So if it has suffered, say, 50% of damages, if that can be quantified, then retaliation also has to be within that 50% framework. It cannot be 90 or 100% as compared to what damages it has actually suffered. So trade effects test is nothing but the concept of proportionality. There's also another rider which says that an arbitrator may not intrude upon the qualitative aspect of the proposed suspension, and the analysis only has to be made with respect to the quantum and the volume. So therefore the question of whether to retaliate in apples or oranges, or whether within a particular agreement or sector or across different sectors also, which sector should that member state choose is not the prerogative of the arbitrator. That amount of discretion is offered to the member states. Now in this regard, this particular concept of equivalence and trade effects test has been to some extent also a debate amongst various academic scholars. I will not go upon into the depths of what has been discussed and debated, but just to give a brief outline of what this debate is. Just Pauline, a very famous trade scholar, has in effect questioned the very nature of why and how the remedies have been designed under the WTO scheme, specifically with the concept of retaliation. He questions whether the real aim of retaliation as it happens in practice is to merely compensate, rebalance the concessions as to what has been lost to you must be given to you, or it is something that goes on to become more punitive. From the aspect of member states, which is the subject of retaliation, is WTO scheme offering them a real opportunity to comply, which is they rebalance their trade concessions when met with retaliation and actually comply, or it is nothing but a system of buyout, whether they are compensating the victim and they are being bought off even though they choose not to comply ultimately. So this whole debate in the context of whether compensation or retaliation is a better scheme, and whether retaliation, what is the main objective of retaliation, whether it is to comply or just be a punitive measure in itself, or between compliance and or between compensation and retaliation, whether compensation is only a mechanism to buy out or it genuinely seeks for compliance. These are the different questions that have been raised, and some of the case laws have been highlighted, whether the importance of each of these remedies have been looked into. So this could be for a future reference. But the academic debate, as I just touched upon, is between compensation and retaliation, and between compliance and compensation. Now we move on to the end of this module, where the last aspect where we touch upon is the critical overview of the various regimes of WTO. Now, furthering to what the debates that we mentioned as to what is the true remedies of, what is the true objectives of the dispute settlement remedies, I bring to you a very classic dispute, the Australian salmon dispute, where this question of removal of inconsistent measures versus conformity to the WTO provisions or the letter of law versus the in-spirit removing inconsistencies within their domestic policy was the debate. Now, to clarify, what had happened was in Australia's salmon dispute that Australia was found to be guilty of certain provisions under the SPS agreement because it did an arbitrary and incorrect risk analysis of what should be banned, and therefore Canada won the case against Australia. And the options before Australia was to either remove its inconsistent measure, which was to remove that particular scheme altogether, or to, and also at the same time to make its provision conform to the letter of law, which is the provisions of the SPS agreement. However, in this case, the two objectives which ideally should go together, which is you have to remove the inconsistent measure and at the same time conform to this letter of law, became contradictory, because Australia, what they did in effect was that now they increased their scope of restrictions that were put on the import of fish, by virtue of which it's not just Canada that was being harmed, but or Canada which was suffering because of the policy, but all the other member states, because the regime adopted by Australia became so stringent. Now, in effect, what has happened is that Australia was able to comply by the provisions of SPS agreement, because the moment its policy was increased in the scope, Canada was not the only one that was being discriminated, and therefore the arbitrary element gets removed, and therefore in theory it conforms to the nature of or the text of the SPS agreement. But in effect, what has happened is that it is leading to more trade restricting effects, for which nothing can be done, because now there is no fresh case which can be instituted against Australia. Therefore, we have a situation where remedy has been designed, Australia technically has complied, and Canada had initially won its case. But what in effect is now happening, that in order to confirm and comply, Australia is increasing the scope of its restrictions, by virtue of which the negative impacts on international trade, or the trade restrictions, have actually been widened in scope. So in theory, the provisions of WTO dispute settlement understanding are being fulfilled. The measure has been brought to conformity with the theory and the letter of law, but at the same time, the dispute settlement understanding cannot do anything to overall target the scheme of Australia, in effect implementing a far more trade restrictive measure. So that's a classic case of a controversy, which it also brings out another drawback of the modern day dispute settlement understanding. Now, a few limitations of compensation. Now, compensation, it's specifically mentioned in Article 22.1 that TSU requires compensation to be consistent with the covered agreements. Now, the moment this is mentioned, it clearly is a contradictory term, because compensation in effect will go on to violate the MFN clause, which is one of the core obligations of the covered agreements. And therefore, in theory, Article 22.1 remains an incorrect provision, or because both of them cannot go together. 22.1, while members are seeking for or members are resorting to compensation, will violate MFN. And till a carve-out is created in Article 22.1, its interpretation cannot happen in the true spirit of the word. Similarly, retaliation, as has been mentioned, a few problems for retaliation, both from the perspective of the developing and the developed world, would be that for the developing countries, if they go on to retaliate, it has certain cost on its own welfare, because if they are increasing their it is in effect increasing their import prices, and these economies are dependent on, for instance, an economy which is the exporting economy against which retaliation is being sought, then the welfare cost gets enhanced, and therefore it becomes an impracticable and inefficient rather tool for the smaller and less diversified economies. For developed world as well, retaliation is not all that easy because, for instance, a country like the European Union has to seek a lot of political will if the tool of retaliation has to be accepted and implemented against member states. For instance, if say Netherlands is facing certain difficulties because of which a case has been instituted and it seeks to resort to say retaliation, it may not go very well with the interest of say another EU country versus Germany, and therefore to gain that kind of a consensus within its organization becomes difficult, and it may not be a very viable solution even for the developed world. Now, quickly touching upon the last aspect, which is the debate of sequencing, which is more of a theoretical problem where a clear inconsistency between Article 21.5 and 22.6 of the Dispute Settlement Understanding gets invoked has been described. So I will not read out the entire provision because it's here, but the question that has to be asked in this context is that have the drafters who wrote Article 22 timetable thought that it will reconcile with the potentially protracted compliance review, which is pursuant to Article 21.5. Now, 21.5 basically states that in case there is a disagreement that a particular member state has complied or not, and whether a country feels that its the member state against whom it's fighting has not complied, it shall refer such a dispute to the dispute settlement procedure, and a fresh panel will be set up based on which the adjudication will be done. However, 22.6 also points out the situation and says, DSP upon the request shall automatically grant authorization to suspend concessions within 30 days of the expiry of a reasonable period unless the DSP decides otherwise. So, in case a country, and here we refer to the classic EC bananas dispute where US believed that EC was not complying, it had two options. It had the recourse of directly approaching a fresh panel and creating a fresh panel under 21.5, or it had the recourse to directly seek for suspension of concessions within 30 days of a reasonable period when it expires and seek the defined recourse. Now, we don't know what timeline runs and whether 21.5 should later come only after countries have exhausted their recourse to suspend concessions, or it should be invoked in the beginning before countries should even go to a 22.6 kind of a remedy. So in this particular case, finally, as we'll see here, that this case was improved because the solution was reached in this case because in effect the panel that dealt with the 22.5 and the 21.6 case, to just clarify, the panel that dealt with both the cases was comprising of the same members. So you had the 21.5 panel and the 22.6 panel, which comprised of the same set of members, and they were able to give out the decision at the same time, because of which there was no particular time lag that happened. However, if different members were sitting in both the panels, that could have led to a deadlock situation where one panel will come up with a scheme where it will grant suspension of concessions, whereas the other panel will still say that the dispute has to be freshly litigated, brought before the panel, and based on what the final results are, members will be free to do what they want. And therefore, this is slight of a peculiar problem that arises in this context, and till a particular amendment happens where a timeline as to what comes before, whether a fresh panel has to be constituted or whether parties may automatically go and seek suspension of concessions, once that issue gets resolved by virtue of a particular timeline, that's the only thing which will lead to consistency in how the provisions can be interpreted. And for any further information, the main handbook could be referred to. Thank you.